Welcome back. I'm Alfred Lambermont Weber, and today we have an extraordinary guest who is Dr. Richard Cordero, who is a doctor of law, graduated from the University of Cambridge in the UK. He's a lawyer based in New York and a researcher writer on federal law. And I contacted Dr. Cordero and his work on judicial discipline reform because I believe that he is doing outstanding work on bringing to public light the systematic problems that need to be reformed in the U.S. federal judiciary. And I say this as a former adjunct professor of constitutional law at the university level and a former judge at the Kuala Lumpur War Crimes Tribunal and other citizen tribunals of conscience. Welcome, Dr. Cordero.
Thank you very much for having invited me to your program. I'm very pleased to be here.
Oh, good. We're very glad that you're here. Now, I would like to ask you, what first got you interested and started in this important work?
Well, as a practitioner, I encountered so many problems, and I realized that it was not simply a coincidence that I was having all those problems. So I started to look for the conditions that made possible for judges to disregard the law, disregard the facts, forget about the rules. And that's how I began to do research in original publications of the federal judiciary. Those are particularly the statistics that are gathered by the courts and then submitted to the administrative office of the U.S. courts. As the name says, this office only provides administrative services, and it was set up by Congress, so it's an official body of the federal judiciary. In fact, the Chief Justice of the Supreme Court is the person who, together with other judges, appoint the director and the assistant director of the office. So this office has to gather the statistics on, for example, the complaints that are submitted by people against judges. Anybody, even a judge, can submit a complaint against a judge, and he has to submit the complaint to the chief judge. He has to submit the complaint to the chief judge of the pertinent circuit. Well, I gather the statistics of those complaints. I tabulated them for more than 12 years, and I found out that on average 99.83% of all complaints filed with the chief judge of the circuit are simply dismissed without any investigation. And that tells you that the system doesn't work. And that system was set up by Congress because the complaints are filed under the Judicial Conduct and Disability Act of 1980. That means 34 years ago.
Yeah, so just, sorry to interrupt you, but just to get that statistic correct, what you found was that 99.82% of complaints are dismissed by judges in U.S. federal courts without any action.
Without any investigation, exactly.
Wow.
And they are not supposed, the chief judge is not supposed to pass judgment on the merits of the complaint. He's simply supposed to review it for formal elements, whether the complaint has been filed with the proper chief judge and whether the judge is subject to the act. But nevertheless, he dismisses of the 13 circuits. There are 13 circuits in the federal judiciary, and those complaints are simply dismissed without any investigation. And then when a person who has had his or her complaint dismissed petitions for review to the Judicial Council, up to 100% of those petitions are denied. Now, the Judicial Council of every circuit is a body of about half of the judges of the circuit, together with district judges and the bankruptcy judge. So this council of the circuit doesn't have any adjudicative function whatsoever. It doesn't decide cases. It provides administration the same way as the administrative office of the U.S. courts provides administrative services for the federal judiciary as a whole. But nevertheless, by law, it received petitions for review of those dismissals. Now, up to 100% of those petitions are denied. Now, this is very important because I was tabulating the statistics for 12 consecutive years. In those 12 consecutive years, in the Second Circuit, you had at least 2 chief judges. It is impossible for all the members of the Judicial Council to agree 100% for 12 years with the decision of 2 different chief judges dismissing those complaints. What that tells you is that there is a systematic denial of the application of the law. As a matter of fact, the judges have abrogated an act of Congress. They have arrogated to themselves the power to abrogate an act of Congress. And they do that in self-interest, because it is in self-interest not to go ahead with any complaint of any one of them. And the reason is very telling. Those judges are life tenured. They can stay in place forever. They do not have to run on elections like state judges that have to raise money and every so many years run for re-election. They are not reappointed. They are appointed once, nominated once by the president, and then confirmed by the Senate of the US, and then they stay there forever. So some of those judges have been in place for 1, 5, 10, 15, 20, or 30 years or more. Like several of the justices of the Supreme Court have been judges for more than 30 years. Now, they know so much of each other that they cannot allow any one of them to be put in a situation where he would be tempted to engage in plea bargain. Like, I give you a bigger fish if you give me leniency. Then I tell you, I give testimony or I give information concerning the wrongdoing of other people, of other judges, or even other members of the judiciary, because of the judiciary has people that are not judges, that they provide administrative services. There are lawyers that provide research for the judges. But any wrongdoing within the judiciary is unconscionable. This is supposed to be the branch of government that provides justice. It administers a justice, and it works under the logo equal justice under law. That is the inscription on the frontispiece of the Supreme Court of the United States. So everybody is supposed to provide justice equally to themselves, to other members of the judiciary, as well as people outside of the judiciary, the people that are parties to cases. And nevertheless, what they do is they use their power to protect each other. Now, neither you nor your audience have to believe me. You can simply go to the official website of the U.S. courts, and you will see there the section on the menu bar of statistics, and then you download the annual report of the director of the administrative office of the U.S. courts, and you will see there for so many years the annual report, which is submitted by law to Congress. And then you can see there the statistics, and you can do what I did in my study. Now, my study is the one that I sent you the link to. And
yes, and is that up on your website now? Judicial-discipline-reform.org.
Yes.
Yes, good. We will provide links to all of those, and that will be in the video description to this interview, so that the viewing audience can go in and they'll have access to all of that. Now, I just want to remind the viewers of some of the summary statistics that you have brought forth, namely that not only are 99.82% of the complaints dismissed, but 75% of them are just summary orders without any reasons. And you mentioned up to 11 additional non-publishable and non-precedential orders. What does that mean?
Yeah, okay. Now, well, before I answer that question, I just would like to point out that it would be better for you and the viewing audience to download the study.
Okay.
So you put the link there that also has Honest Jude Advocates PDF.
Okay.
Because what I have done is not to put the information on my website.
Okay.
I have had so many problems, and I do not want people to be dependent on the website still being allowed to be on. So what I do is I put all my study on a PDF. It has thousands of internal links. It works as a website that you can download. So when you normally go to a website, you see many links that take you from one page to the other.
Yeah.
I've done that exactly in my file. I have thousands of internal.
Yes, so just before the interruption, you were talking about why you have gone ahead and prepared all of these PDFs, which we're going to have a convenient place where people can download the
PDF.
Yes, yes. And I just want to mention to people that, so that they understand the pioneering work that Dr. Cordero is doing, and not to make too much of it, but it should be part of the record, that just before airtime today, this morning in New York, Dr. Cordero's laptop was mysteriously taken out, and he's using a laptop borrowed from a colleague for this Skype interview. So he is under a great deal of targeting, I believe, in my considered judgment, and he's a very courageous professional to bring this information forward. Now, I just want to mention this by way of context, Dr. Cordero, because you're bringing to light that in the entire history of the United States, only the entire 225 years, is it only 8 judges have been dismissed for cause? Is that it?
Have been impeached only 8 judges, and for comparison, on September the 30th, 2011, there were 2,131 justices, judges, and magistrates in the federal judiciary, which means that since its creation in 1789, 225 years ago, there must have been many more thousands of judges, and nevertheless only 8 have been impeached and removed.
And so what you're really showing through these statistics is that this low number is not because of the impeccable conduct of the judges, but because of a systematic arrangement within the judges to suppress any complaint against their impeachable cause of conduct.
Yes, and it is important to notice that from the beginning there was no system for monitoring judges. It was precisely because some senators in the U.S. Senate realized that there was no mechanism to impose discipline among judges, that they came up with the act that I mentioned before, the Judicial Conduct and Disability Act of 1980. And it was supposed to allow people to complain, because before that there was no organized formal system for complaining against a federal judge. And nevertheless, it hasn't worked. But what is more important is that the fact that it was a Congress that adopted in 1980 this act, and that has received the annual report with the statistics on those complaints for now 34 years, and nevertheless nothing happens, nothing has changed. Now, if Congress receives this annual report with the statistics of complaints and sees that year after year nothing happens, the complaints are dismissed. And it is important to notice that the categories of these complaints are dramatically important. They include bribe, they include conflict of interest, failure to make decisions, so corruption. So the administrative office of the U.S. courts knows that the complaints that are received by the different courts and that are then transmitted to them statistically are very important, are very serious. How is it possible that they are dismissed systematically by the chief judges? Congress knows that because it receives the statistics annually showing that year after year there is no investigation. There is a provision in the law to set up a committee to investigate a complaint, but no committee is set up. And as I mentioned before, when the petitions for review of those dismissals go to the Judicial Council of the respective circuit, they are dismissed even at the rate of 100%. That means that there is a connivance between Congress and the judges. The senators and the members of the House have allowed judges to abrogate one of their acts, and they do that in self-interest because they know full well that if they were to be known as the nemesis of the judges, one day they may appear before a federal judge on charges against them, and then the judges would retaliate against them. And this is not a far-fetched possibility, because if you see the statistics and the names of the senators and other members of the House that I have on my study, you will see that even though in Congress there are only 535 members, which means about 1/4 of the judges and magistrates in the federal judiciary, in the last decade, there have been more members of Congress removed for corruption, even imprisoned, than in the whole 225 years. There have been members of the judiciary removed from the bench, because it is not the same to remove a judge through impeachment and going to jail. Through impeachment, you simply remove the judge. Nothing happens after that. You would have to file, that means that the prosecutor, that means the district attorney, a person with authority to prosecute charges, would have to file charges against that judge that has been impeached in order for him to either pay a fine or go to jail. So you can do whatever you want, knowing that you are not going to be removed as a matter of fact. But if you were to be one judge that every 30 years is removed from the bench, nothing would happen to you, unless the district attorney would file charges in court in front of your colleagues to bring charges to you, to impose a fine or to send you to jail. And he is not going to do that, because if he does that, the judges before whom he would have to bring charges would close ranks, and that district attorney, and in fact the Department of Justice, would not win a case again because of retaliation. So it would be simply a matter that the judge would lose his office, but nothing would happen after that. It is not even certain that that person would not receive his pension. There was a judge in the South that was impeached and removed, and the Congress still had to pass a personal law. It's called a restricted act to remove that person from the federal salaries, so that that person would not continue receiving his salary or his pension. This is simply beyond belief, that you can do everything. If you are caught, you lose your job and nothing happens. So there is a connivance between the judges and the members of Congress, and there is also between the judiciary and the president, and there is a precedent for that. When Roosevelt began with his New Deal laws in the late 1920s and particularly the early part of the 30s, his laws were declared unconstitutional when they arrived in the Supreme Court, one after the other. So Roosevelt tried to pack the court, to put more members on the Supreme Court, but that was deemed to be an interference with the judiciary, and that proposal did not go through. But everybody, even the presidents, realized the immense power that judges of the federal judiciary have to doom to failure the legislative agenda of a president by simply declaring it unconstitutional. And President Obama came within a whisper of having that done to his Obamacare Act, which is his signature legislation. If the Chief Justice, who is a conservative, had voted with the other 4 conservative on a court that counts up 9 justices, Obamacare would have been declared unconstitutional. The Chief Justice switched side and voted with the other 4 liberals, and that is why Obamacare, instead of having gone down in history as in a footnote, it is now the law of the land. But that tells you that the president was very much aware that he ran the risk of having his signature legislation declared unconstitutional, and then he would be a failure of a president. That's why the Department of Justice, that obviously is a part of the executive, doesn't prosecute judges, doesn't investigate them, because it would simply provoke a retaliation on the part of the judges. And that means that there is this class of people above the law. As a matter of fact, they are above the law. When you can have a job security beyond any question for life, earning a salary that is on average 4 times the average salary of Americans, then you know also that the journalists are not going to take you on because they would be exposed to retaliation. There is nothing that can be done to you as a federal judge, neither in the press nor by the authorities, by the Department of Justice, by Congress that can conduct its own investigation. You can do whatever you want. You are above the law.
Let me ask you two things, and then I'd like to go on to the topic of the concrete ways in which their wrongdoings of the judges harm people. But I'd like to quickly one is the secrecy of the meetings in these attempts to complain against judges. And secondly, you brought up a figure of $373 billion in 2011. Could you talk about those two things briefly?
Yes. Can I answer the question, because it is very related to this?
Sure.
The decisions. You mentioned before 75% of appeals. It has nothing to do with complaints.
Okay.
These are regular appeals.
Oh, regular appeals. Oh, I see.
Regular appeals of cases that are submitted to the circuit courts. So in the federal judiciary, you have 4 levels. You have the bankruptcy courts, right, the district courts, the circuit courts, and then the Supreme Court.
Oh, right. Okay.
So when they go from the bankruptcy court to the district court to the circuit courts dismiss up to 75% of all appeals by just a piece of paper that
denied.
No, on the contrary, affirm. Because
affirm. Sorry, right. That's what I mean.
Affirm the decision
Yeah.
of the district court below, because it would be so much more difficult to read all the briefs, check the law, and then write a decision stating what was the reversible error that the district court below committed, so that on remand he doesn't commit the same mistake. That would defeat the purpose of the summary order, which is simply a mechanism to dispose of appeals summarily with nothing done. And when I say nothing done, he said that you have only one operative word that says affirm. That's it. Summary order, that means that there is no discussion, there is no reason. But not only that, as you mentioned before, up to 11% of additional decisions are reasonless. They simply have a statement that is so poor that the very same judge that wrote it writes not for publication and not precedential. Not precedential means that you as a party cannot cite to that decision as precedent of what the judges did before. And now, what does that mean? That a judge that writes an opinion so poor that he doesn't want other people even to have access to it, he writes not unpublishable. But if they were to get to that decision, because they go to the courthouse and get it there, it would be useless because it has no precedential value. So that means that a judge that writes an opinion like that can write it arbitrarily. It doesn't matter. It doesn't count. It is as if nothing had happened because nobody else can use it, even though our system, like yours, is based on precedent. You establish a pattern of law by harking back to what other judges have decided in other cases that are similar, or you establish that there is a difference and the precedent should not be applied. But nevertheless, there are some rules, there are some parameters that you can invoke by referring to decisions that have been made before. In this case, there's nothing like that. 75% of the decisions by summary order doesn't have anything that you can refer to. It simply says affirm in most cases. And in the other cases, by the decision of the judge himself, it is not precedential. It has no value in any other case. Now, what you mentioned about $373 billion, it is that in the bankruptcy courts, which are the courts at the lowest level of the federal judiciary, 80% of all cases enter through the bankruptcy courts. That means that bankruptcy cases constitute 80% of all annual cases newly filed in the federal judiciary. 95% of those cases that now average 1.3 million new bankruptcy cases filed in the bankruptcy courts of the federal judiciary. 95% of those newly filed bankruptcies are filed by process, by people, persons. The immense majority are filed by persons without representation of a lawyer, for the very simple reason that if you go bankrupt, then you do not have money to pay $100, $200, $300, $400, even $500 per hour to a lawyer. So you have to fend for yourself. And you do that by filing a bankruptcy petition, which means that you have to fill out the forms. The forms themselves are so difficult that even the administrative office of the U.S. courts have put out a warning to bankrupts that they should try to seek legal advice, because there are so many of those forms that are returned because they are poorly filled out. Now, when you realize that the form themselves is so difficult, you can forget about understanding the bankruptcy code, because this is beyond belief, particularly for a person who has no training in the law. When you read those provisions that send you to another provision, with the exception of this, taking into account of this other thing, it is very difficult for a person that has not received any training in the law to think in that way. So forget about invoking the bankruptcy code or the regulations. You simply do your best by trying to fill out the form, and you submit it to a trustee. The trustee is supposed to represent not you, the bankrupt. You are the debtor. It is supposed to represent the creditors. But the trustee is the one who has the power to recommend the plan of debt repayment that you as a debtor propose to the judge. The trustee is the intermediary representing the creditors, but he's not a completely uninterested party, because by law he receives 10% of every payment that you as a debtor make through the trustee to the creditors. So you are the debtor. If I am the trustee, you pay me. By law, I can keep 10% and then distribute equally the 90% left to the creditors. But before that happens, you submit the plan to me. I check it, and then I ask the judge to either approve it or disapprove it. Now, what happens? Obviously, if I, as a trustee, disapprove of your debt repayment plan, I don't get my 10%, because you're not going to make any payments, because I recommended to the judge that he denies that debt repayment plan. So it is in my interest as a trustee simply to accept anything that comes my way, because then I know that I can get my 10%. Obviously, if the judge approves it. Now, the judge is going to say, hey, trustee, you know what? I have the power to declare that you should be removed from this one particular bankruptcy. But what is the consequence of that? If the judge removes a trustee from one single bankruptcy case, he is removed from all cases. He loses his livelihood as a bankruptcy trustee. And then he's back in queue at the indigent defenders courthouse asking for an appointment. So he has no interest whatsoever to get on the wrong side of the judge. Now, the judge then has an interest in telling the trustee, listen, you come here every day with these recommendations that I accept the debt repayment plans of those bankrupts. And I have to do all this immense work of signing them. That's my work, and that is a lot of work. And you know why it is a lot of work? Because if I don't sign it, if I don't approve it, you don't get anything. And all effort that you may have made in reading those things or simply putting them together and bringing them to me would be for naught. So from now on, I want you to express your appreciation of my signature. That's the way that instead of me telling you, okay, from now on, you were supposed to pay $1,000 to your creditors. I was supposed, by law, completely legal, to keep 10%, that means $100. And then I was supposed to pay $900 to the creditors. But I think that we can do better than that. I'm going to say that instead of you having to pay, let's say, 30 cents on the dollar to your creditors, you're going to pay only 15 cents to the creditors on the dollar. And now of that $1,000, you are going to give me $500, and you are going to keep the other $500, and this is a win-win situation. Except that when the judge knows that, he tells the trustee, this is not a good deal for me because I'm not getting anything and I am doing all the work of signing the paper. So what I want you to tell the bankrupt is that from now on we are going to get $750. I'm going to get $500, and you are going to get $250, and the bankrupt is going to save $250. And if he doesn't like that, you can always tell him that instead of paying 15 cents on the dollar, he's going to pay 35 cents on the dollar. Now you may think that
but wait. So what you're saying here is that the judges are taking money under the table?
Well, that the system allows them to do that. The system has the incentive to do that, and then there are signs that the system is corrupt, because of when you read the law says that the trustee who represents the creditors has to personally perform a series of acts concerning each bankruptcy case personally.
Yeah.
It is a removable cause for the trustee not to perform those actions personally, and I have seen them all in my brief with reference to the bankruptcy code of provision or the rules that require the bankruptcy trustee to perform personally those actions.
Yeah.
When you find that a trustee can have 3,900 bankruptcy in his name, or 3,300 bankruptcy to his name, there is no way in this world or the next to come that he can take a personal care of those decisions. The only way he can do that is if he's running a bankruptcy mill, where whenever a bankruptcy comes his way, he doesn't even look at it.
Yeah.
He just signs the petition for the judge to approve the bankruptcy, and that's it. And then he keeps the 10%, but what is more? He can engage in those corrupt arrangements with the bankrupt and with the judge.
I see.
And there is evidence of that, because before the current system, it was the bankruptcy judge that would appoint a trustee.
I see.
For example, here in many states, it is the judge who appoints a guardian for a person that cannot take care of himself, and that has led to so much corruption. Why? because when you have the power of appointment that allows an appointee to earn money, you always have the incentive to sell that power, to say, yes, I can appoint you time and again if you and I come to an arrangement and I get my part and you get your part, and everybody
I
is
see.
the other person.
And there's no enforcement against the judges for the reasons that you have cited earlier.
Exactly.
That the judges are in self-protection.
Exactly.
So
Exactly.
we have a corrupt federal judiciary, is what you're saying.
Yeah, but in addition to that, you have to understand one thing, that bankruptcy judges are not nominated by the President of the U.S. and confirmed by the Senate. No.
I see.
They are appointed by the circuit judges.
I see.
Judges appoint the bankruptcy judge. Now, you have to realize that if the bankruptcy judge is challenged, when his challenge decision comes to the circuit judges who appointed him, do you think that the circuit judges are going to be impartial when it is the decision of their appointee that is at stake? The normal human reaction is to say, I appointed him because I thought that he was a clever person and a competent one. So from the outset, I am already a partial judge. I have an interest in finding the decision of my appointee to be valid, because otherwise I would indict my own good judgment in having that person appointed as the bankruptcy judge. So the system is created in a way that it promotes corruption, particularly when you know that it is also the circuit judges, together with the district judges, that can remove the bankruptcy judge. It is not the procedure of going to the House of Representatives to impeach the judge and then approve the articles of impeachment and pass it on to the Senate, a very complicated system. No, it is simply the circuit judges and the district judges that can remove the bankruptcy judge. That means that the bankruptcy judge has no interest whatsoever in challenging whatever decision, whatever insinuation the circuit judges and the district judges may make to him. The bankruptcy judge has the power to remove the trustee by simply saying, I remove you from this one single case, and your 3,900 other cases, forget about them because you are automatically removed. So he has an enormous amount of power in deciding not just whether the trustee remains in place, but also in disposing of that $373 billion at stake in only the personal bankruptcies. That means that the 5% of bankruptcies annually filed by companies are not taken into account in that 373 billion. That is simply persons that file pro se in the majority of cases because they cannot afford a lawyer. So when the judge says, no, provision of the bankruptcy code 3525 applies here, the bankrupt who filed pro se have no clue what the judge is saying. He can allocate the money at stake to repay the creditors however he wants. What is more, before that, there are other members of the legal and bankruptcy system that also get their take. The accountants, the auctioneers, the warehousers, the lawyers, they all have a system of working together with the trustee, because the trustee is the one that can say, well, I need a lawyer. The trustee doesn't have to be a lawyer. He simply has to be appointed by the office of the U.S. trustee. It is a federal office, but he's not paid by the office of the U.S. trustee. He's paid by his 10%. So if he doesn't get the bankruptcy petitions approved by the judge, he doesn't get any money at all, because he is not a salaried federal officer. He is an independent contractor, in the sense that he is appointed to be the trustee representing the creditors, but he is only representing himself, because the only way he can get money is by approving every petition for bankruptcy that comes his way, because it has to be submitted to him, and then recommending the approval of it to the judge. And it is important to dwell on this, because $373 billion is more than a third of $1 trillion. It is an immense amount of money. If you just take one single piece like this, you get an enormous amount of money that you can distribute between the people that make the system. In fact, the system was so corrupt before 1984 or so, when the new system that set up the U.S. trustee was in place, that the whole bankruptcy system had to be remade, because the judges who were at that time appointing bankruptcy trustees had a system that the investigation of Congress called cronyism.
Well, I mean, the 10% of 373 billion is 37.3 billion. That's the stake that goes to the trustees, which are the cronies. That's a lot of money.
Yeah, that is a lot of money, and with that you can do a lot of things. And what is important is to see how the system works. When you know that